Welcome to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and California Supreme Court. And now your hosts, Tim CALaw and Jeff Lewis.
Welcome, everyone. I am Jeff Lewis.
And I'm Tim CALaw, operating under an expired license from the California Department of Podcasting. In each episode of the California Appellate Law Podcast, we provide trial attorneys with legal analysis and practice tips from an appellate perspective. Both of us are appellate specialists who split our practices evenly between trial and appellate courts. We both work directly with trial attorneys to prepare cases for appeal. In this podcast, we offer some of that appellate perspective on various issues that arise in trial court and on appeal.
All right, and welcome to episode 14 of the podcast.
Right, and today we welcome John Reeves to the show. John is an appellate attorney whose practice focuses on federal, appellate, and Supreme Court litigation. His practice is based in St. Louis, Missouri. You can find John's numerous amicus briefs in any number of high-profile constitutional litigation, including a recent petition for certiorari to the U.S. Supreme Court from a decision in the California Supreme Court in Marin Housing Authority versus Riley, which we'll be talking about on the show today. So welcome to the podcast, John.
Welcome. It's a pleasure to be here.
So as I mentioned, your practice is based in St. Louis, but you're obviously very engaged in a lot of national and federal litigation and appeals.
Yes.
How do you choose what cases to get involved in?
Well, Tim, that's a good question. A lot of it is referrals, trial attorneys, other appellate attorneys who may have a conflict referring a case to me. That's obviously the first step, where you have a trial attorney or someone who's lost at the initial court of appeals or the state court of last resort. If they want to go to the United States Supreme Court, they're looking for a specialist. And through networking, other lawyers say, well, why don't you look at so-and-so, Mr. Reeves? He's a guy who's done stuff in the U.S. Supreme Court and other stuff throughout the country. So that's one of the ways. Now, in terms of, it's mainly through word of mouth. It's very important for an appellate specialist to have a good relationship with trial attorneys. Because of my practice in the appellate context, the trial lawyer is almost the appellate lawyer's client just as much as the client itself is. You're working with the appellate the appellate specialist is working with the trial attorney, and obviously that also includes maintain good relations with other appellate specialists. I've over the last year and a half, I started my practice about a year and a half. I've among other things, I'm co-founder and co-chair of the Missouri Bar's and Appellate Practice Committee. I also have some contacts in DC from various appellate groups and appellate attorneys. And a lot of it is just getting a call one day and hey, I got this case. You may be interested. Would you like to take a look? Sure, absolutely. And of course, then the question is, how do you get to that point? Well, a lot of that is social media, publishing articles, having a good website, and just a lot of networking. Now, to further answer your question of how do I take a case if it's presented to me? Well, the first thing I'm going to look at, obviously it depends if it's a matter for asking a court with discretionary review to look at, like the U.S. Supreme Court. The most important thing I look at, and that any appellate practitioner at that level should look at to begin with, is there a clear split, either among the federal appellate courts or among the state courts of last resort? If there is, you've already satisfied the first difficult hurdle to clear.
Right.
The vast majority, I don't have percentages or any statistics in front of me, but the vast majority of cases on which the U.S. Supreme Court grants cert are those cases where there's a circuit split. It is possible.
Do you see that there has to be a more than just one, two circuits and them being split? Is that to be more than two or three or four circuits?
Yes and no. So it depends. It depends entirely. That's the big question. There really isn't a good answer to that. Sometimes there can be. The courts grant cert where there's just one split, where two courts disagree with each other. Other times they don't grant cert until there's a split that develops more and more. One instant. Now, of course, then there's well, what do you mean by a split? Is it one court disagreeing with each other, or is it where 9 or 12 courts have always concluded this one thing, and then so you have this 15th case where this one court's conclude the opposite, and then whoa, wait, yeah, that's a big outlier there and whatnot.
Yeah.
That again, I don't have any statistics, and it doesn't really matter what the subject matter is either. The split, looking for a split, is the most important thing, and you're in a much better position if the lower opinion you're trying to get reviewed explicitly acknowledges the split. I'm not saying it's not possible otherwise to get cert, but you're in a much easier position if the lower court opinion explicitly acknowledges the existence of a split. So
that's interesting.
yeah.
Is there a strategy to do that, to kind of tee that up for the Circuit Court of Appeal, so that they're aware, and that they kind of tee that up for maybe a petition for cert?
You certainly should. I think any good appellate specialist at the, when you're one level down, whether it's at the state appellate court before seeking discretionary review from the state Supreme Court, or the federal Circuit Court of Appeals before seeking cert in the U.S. Supreme Court. You should definitely want to tee that up, and not just for purposes of saying up for discretionary review later, but also because that's part of being a good appellate practitioner at the initial appellate stage anyway. If you've got a major case, I don't care if it's in state or federal court, on a major legal issue, and there's other out of circuit or out of state authority examining the exact same legal issue, the exact same statute, if it's federal or state, I suppose. I depend on what the state is, but I digress. But if you've got outside authority coming to a different conclusion from what you're arguing, or if it's clear there is a split, that is something that any appellate practitioner, even before you're thinking of cert, should alert the court to. That makes the judges clear, that alerts the court to the fact that, hey, this is a serious issue here that requires a real in-depth analysis, and you're going to want to let them know about those other cases, regardless of what the view is, so that can add to the argument. Because the worst thing, at least if I were a judge, the worst thing that I would want is to publish an opinion in my jurisdiction thinking, okay, yeah, this is real clear cut, obviously, and then only find out after the opinion's handed down that this whole time there's been an outside opinion from another authority examining the same thing that came to a different conclusion.
Yeah.
So,
and as an appellate attorney, are you looking for opportunities in the district court itself to make the record that early in the case, or are you mostly getting involved when it's already up on appeal?
Do you mean in my capacity as an appellate attorney, or do you mean just when you're doing the motion, when the trial attorney is doing the motion? Like, do you mean like me as an appellate attorney? Am I looking for opportunities to get involved in the case itself then?
Yeah, as early as the district
okay.
court to build up the record.
Sure. Sorry about that. Yeah, absolutely. That is actually an aspect of appellate practice that has really developed and sprung up in the last 15 years. There's two parts to that. One, appeals themselves have become so more specialized. You have trial lawyers more and more going to appellate specialists to handle the appeal. But even before that, you now have, and this is relatively new, it's only been going on for about 15 years, you have trial lawyers seeking appellate specialists at the trial level to basically be in the background and to serve as like the person who's looking at the case from the long game. While the trial attorney is doing the discovery and is developing all the factual theories and whatnot, and looking at what's the strategy for if this goes to trial, or even summary judgment in terms of establishing the record, you've got the appellate specialist in the background who is doing the research, looking what the more broader issues are, making sure that it's clear what your jurisdiction's rules are regarding, as you said, preservation of error at trial. And even before that, even at summary judgment, making sure that whatever the standard of review is for summary judgment, in the event that, if you win and then the other on summary judgment, and then the other side appeals, you want to make sure that the arguments you've made are clear cut and everything. And an appellate specialist brings that kind of perspective that not the trial attorneys lack. Don't get me wrong. I'm not saying that. It's it's just a different perspective. It's a complementary perspective that fits in with what the trial lawyers do.
Yeah. Well, Jeff, see, I see my attempt at light banter has turned into a disquisition on advanced trial and appellate strategy. So maybe we should move on to the actual meat of our interview today and talk about Marin Housing Authority versus Riley. And I thought our listeners would be interested in hearing you talk about this case, John, because it illustrates how decisions made in our judicial system here in California can get the attention of appellate attorneys like yourself in other states. And I also thought we could talk about, maybe after we talk about the Marin Housing Authority case, we could talk about amicus briefs more generally, and how to, maybe how practitioners can involve that as part of their appellate strategy. So
Sure.
let's set the table briefly to discuss Marin Housing versus Riley. The California Supreme Court just issued its opinion in that case, and now there is a petition for certiorari to the United States Supreme Court. And the case involves Section 8 rent subsidies, I understand, and apparently some Section 8 recipients also receive compensation for providing in-home care for disabled family members, for example. So the question that arises is, what happens if that compensation takes them above the threshold for receiving Section 8 aid? Does that compensation count as quote unquote income for determining need for Section 8 assistance? So John, if you would set up the basic facts of the case and then how you came to be involved in it.
Gladly, yes. Thank you, Tim. So basically, as you said, this case involves, there's two separate statutes at issue here. As you said, Section 8 is a Housing and Urban Development, a HUD statute. The other statute is a state California Medicaid statute. The plaintiff in this, I apologize. The plaintiff in this case, Marin Housing Authority, is a local agency that provides Section 8 housing to certain individuals who qualify because they're below they don't go above the threshold income. The individual in this case, Carrie Riley, stays at home full time to care for a disabled family member. She does this full time, and and she's elected to do this herself. And for reasons I'll get into this in a moment, that's critical. Instead of paying someone else to come in and look after her family member, she is doing this herself. Now that's critical because under this California Medicaid program, it provides money to eligible recipients to care for a disabled family member, and they can use the money in one of two ways. They can use the money to pay for a third-party medical service provider to come in and care. So like hospice or whatever kind of medical needs you have, and you basically pay their fee. The state pays the family member, who then pays the third party to care for the disabled family member. Or the recipient can use the money himself or herself to basically work, stay at home full time, and care for his or her disabled family member.
Right. So there's a policy objective there or some may have the policy objective. Apparently the California Supreme Court believes that these people caring for disabled family members should be able to receive that income without risk of being taken out of the qualification for Section 8 housing assistance.
Yes. And so what happened, I apologize. Go ahead, Tim, please.
Oh, no. Yeah. And obviously there's a question whether that's what Congress intended, or whether even if it did intend that, did it expressly or sufficiently evince that intent in the text of the statute?
Yeah. And so and here we get to the critical, and I should also add, and this is important in the context of is it, just to circle back around, where is a case cert worthy or not? In this case, there's no factual dispute, as I'll say in a second. And that's another instance where, because the facts are undisputed, that makes it more likely to be a good candidate for cert. So nothing I'm saying here is disputed. Neither of the parties really dispute the facts here as we're discussing this. So it's undisputed that Ms. Riley lives at home full time to care for her developmentally disabled family member. And the money she receives from the California Medicaid program is, for all practical purposes, her salary. That's her salary for her full-time job to care for her developmentally disabled family member. Now, what does this have to do with Section 8 of the relevant HUD statute? Well, the relevant HUD statute says that to receive HUD funding, you have to be below a certain income threshold. So how do you calculate income? Well, the relevant portion of the HUD statute here that in part of the definition of what income you count towards whether you exceed the threshold to receive HUD assistance, it says this is what's excluded. So you do not count what I'm about to quote as towards your income. Amounts paid by a state agency to a family with a member who has a developmental disability and is living at home to offset the cost of services and equipment needed to keep the developmentally disabled family member at home. So that's the key phrase is the money that Ms. Riley that she receives from the California Medicaid program, is that an amount paid by the state to offset the cost of services and equipment needed to keep the developmentally disabled member? Now, if she was taking this money and paying a third party, like a third party medical service provider to do this, there'd be no issue whatsoever in it. Those certainly are costs and services. But what happens when she's using this money and it's literally her salary? And here's where we get into the policy problem, because what you're basically saying is that if this is the case, if that's included, if what's basically her salary is included in it, then that sort of puts her at an advantage that someone else who might receive the same income as she does, but who's working at some other job,
Right.
she won't be considered.
Right.
The other,
Are there examples of other types of income that the IRS, for example, would count as income, but is not included as income for Section 8 purposes?
Well, that's interesting. There was some talk in the opinion, I can't remember where, about what the IRS defines as income. And actually, it's funny, the California Supreme Court looked at the IRS definitions, but the dissenting opinion, as well as the cert petition, again, I apologize I can't remember off the top of my head what it was that the California Supreme Court used for the IRS to support its position. But the dissenting opinion and the cert petition and my amicus brief, frankly, make the point that you can't use those definitions. The statute, this isn't taxable income here. This is what income qualifies, what income has HUD defined as, I apologize, what monies has HUD defined to qualify as income for purposes of receiving
So
HUD aid.
They're on two different tracks then: income for tax purposes and income for HUD assistance purposes.
Yes.
Got it.
And the other problem is the dissenting opinion pointed out, the dissenting opinion was very charitable. I wish all dissenting opinions were written like this. It was a 4-3 decision. The dissenting opinion was, while it was merciless in attacking the logic of the majority opinion, was very gracious in doing so. And it said something equivalent of, we can certainly understand the concern and the good motivations behind the majority opinion in doing this, but there's two problems with it. One, this isn't what Congress intended. It runs contrary to the text of the statute, and we'll get into that, or of the regulation I just quoted. That we could talk about that more a little later. But two, as a practical effect, this is going to make far more people eligible for HUD housing, and in the process, HUD funding isn't unlimited. I mean, money doesn't grow on trees, to use the old saying.
Right.
And there are people literally backlogged waiting to get HUD funding who are eligible, who don't have it yet.
Right. So people who are getting this increased income are arguably taking away money from people who have less income.
Yes.
Who equally need that housing, or maybe they have even a more dire need for that housing.
Exactly. And again, I apologize. I can't remember what the amounts were that Ms. Riley was receiving in this case from the Medicaid agency. But again, what you said, that just goes to prove the deeper issue of, under that rationale, if you accept the California Supreme Court's rationale, her income would count towards being reduced, would be excluded for HUD purposes, but someone working somewhere else, doing some other job, making the exact same amount of dollars per year, that wouldn't be excluded.
Yeah.
So that's an issue. And so yeah, it's a
Okay.
very serious policy issue. Yes.
Yeah. Yeah. So yeah, we have a taste of the facts. We have a taste of the policies at stake. Let's talk about your interest as an amici and the other amici involved. Who are the other amici involved filing amicus briefs, and what are their interests concerning this case?
Sure. Okay. Well, so I'll start off with the amicus entity I filed on behalf of is the Scott County Community Development Agency. Now they're based in Minnesota, and that actually ties in with how there is an explicit split in this case between the California Supreme Court and two other jurisdictions. There's a split in this case. The California Supreme Court explicitly rejected two earlier cases, one by the Fifth Circuit and one by the Minnesota Supreme Court, that concluded that this income cannot be excluded. And Scott County, the party that I represented as the amicus, was actually the party in the Minnesota Supreme Court that ended up winning. So their interest, and so that's the amicus party I'm representing. There's only one other amicus party that filed an amicus brief in support of cert being granted at this stage, and that's excuse me, I apologize. This is the California Association of Housing Authorities, and they're like an umbrella group of various local housing authorities in the state of California. They're charged with administering the HUD regulations, and both their interest and the interests of my group, Scott County, they really aligned. We made sure that the briefing wasn't repetitive, but basically the California group, they focused primarily on the policy matters and how, as we were saying, this is just going to further drain the already limited funds they're needed to provide assistance to these people. My brief in turn amplified on what the circuit split, on the nature of the circuit split between the California Supreme Court on one hand and the Minnesota Supreme Court and the Fifth Circuit on the other hand. As I said, both the Fifth Circuit and the Minnesota Supreme Court, they came to the separate conclusion than what the California Supreme Court did.
Interesting. So what's the tactical advantage to splitting up the issues like that, rather than both of you covering both issues in your briefs, or just one of you filing a brief or filing a joint brief? Can you talk about those kinds of considerations?
Absolutely. Well, the most important thing an amicus brief can do, why do you want an amicus brief? It's to bring the court's attention to some matter that the briefs on the merits weren't able to address, either for lack of time or maybe or for some other reason. That's the first thing. The second thing tied into it, that is, an amicus brief gives the court an opportunity to look at the case from a broader picture. That when you see a part, that it prevents the court from being so focused just on the two parties here. It enables them to see what the broader consequences could be or are to this issue. That if they rule this way, what could be, amicus briefs can bring to the court, what are some of the other consequences of this issue that maybe the main briefs haven't been able to address because of time constraints. And related to that, and I always say this, any good appellate practitioner will tell you that the worst thing you can do in writing an amicus brief is just regurgitate what the briefs on the merits have said. That right. Unfortunately, that happens more often than it should. There are few things in this world that annoy appellate judges more than repetitive amicus briefs. They don't have all the time in the world. They're busy. They have other things to do. They don't want to sift through, a long brief that just repeats what
they're not reading briefs for pleasure. They're reading because they're paid.
No.
Yeah, that's a great point.
Yes, hard to believe that the judges are. I know it's stunning to all of us, but
I was just gonna say every brief, every appeal involves a mistake that was made by the trial court, and somebody arguing it should be reversed, and somebody arguing there was prejudicial error. And the real role of amicus briefs is to demonstrate the policy, the why the justices should care, and why they should reverse. And they should, in my opinion, amicus parties should spend 90% of their effort or word count on the why and the policy implications of granting or not granting relief.
Yes, I fully agree.
Yeah.
I fully agree. And on that note, just to add one more thing, just to make clear what the status of the case is right now, the cert stage briefing's been completed, and the court actually about a month ago, after it was submitted, issued an order calling for the views of the United States Solicitor General. It's asked the Solicitor General's office to submit its own brief, amicus brief, informing the court what it thinks of the case. Should cert be granted? Should it not? So it'll be very interesting to see what happens with that.
Are there any rules against amicus or different amici from coordinating their briefs with one another?
That's a great question. No, there isn't. There's some lawyers who aren't familiar with the process I've noticed they can be a bit reluctant to try and coordinate. By lawyers, I mean the lawyers for the parties on the merits, who they may, oh no, that is this, they may think that, well, is this wrong to collaborate? But there's nothing against it. I mean, as long as you're not going to share any attorney-client privilege there, but no, there's absolutely nothing against that.
Okay. Now I noticed that Marin Housing Authority asked the court, the California Supreme Court, to stay the issuance of the remitter pending the filing and disposition of the petition for writ of certiorari in the Supreme Court. The California Supreme Court granted the stay. I wanted to ask you, is that common in your experience from what you've seen? Do parties ask the state high court, if the parties intend to take a petition for writ of certiorari to the U.S. Supreme Court, is it common to ask the state high court to stay issuance of the remitter?
I'll answer that question in two parts. One, it is common for the parties to ask a stay of the issuance of the remitter if the circumstances are such that it will harm the party seeking review if it's not stayed pending the time that they do cert. And I'll get into that more in a second. The second question, which is a subset of your first question, how common is it for the California Supreme Court or any other court to grant a stay of the issuance? That is a relatively rare thing for them to do. It's not unheard of, but it is relatively rare. And just to give a broader perspective, what you call the remitter in California is called the mandate in the federal appellate courts and most of the other state appellate courts. In fact, as a side note, as a Missouri practitioner, that's one of the things I love about the California state courts. You guys still use all those old school common law terms and everything. Like you guys still have the demurrer and everything. And
we're not very progressive in that way. Yeah.
Irony of ironies, right? But just and I don't want to. And again, feel free to stop me if I go down a rabbit hole here. But just for your listeners to understand what we're talking about with the remitter, what the remitter is on the appellate level, or what, like I said, it's the remitter in California, the mandate in the federal appellate courts is after the appellate decision is issued, the parties have some time, typically 14 days or so. I apologize, I don't know what it is in California, to ask the court to reconsider the case, go rehearing if it's the federal appellate courts en banc, or just to rehear the case. If and when that's denied, the remitter is issued, or the mandate. What the remitter does is that's the legal mechanism that actually sends the case back to the lower court for the lower court to enforce whatever judgment it is that the higher court ordered it to do. So basically, now you get to the trial court can enforce the judgment now. So in this case, what's the thing that the trial court has to enforce? It has to enforce the fact that Ms. Riley is that her income her payments from the Medicaid do not count as income, and that's binding now. Well, the problem is you have it takes a while to prepare a cert petition, and the cert process is such that normally the de facto position is, even while you're writing a cert petition and you file with the court, they're waiting to hear it, there's no legal mechanism allowing the trial court to not enforce its judgment during that time. Right, so during this whole
so it's
time,
going to cause harm to the petitioner there, and
irreparable harm, and that's the key there. That even if cert is granted and the court finds out that the petitioner show won, it's like, whoops, you just failed to collect all this money, or you just, we really can't fix it. Sorry, it's sour grapes. So
does that lead to an issue of potential mootness for the petition for certiorari if this order that's requested to be reviewed by the U.S. Supreme Court is already being enforced and causing harm? Does the Supreme Court look at that as making its ultimate remedy potentially moot?
That's a really good question. I'll admit I never thought about that. The standard that they use doesn't include the concept of mootness, but I suppose it could. I can't think of a circumstance under which it would, but that's an interesting concept. I suppose it could. So,
but mostly what's animating it is just protecting the client from irreparable harm.
Exactly. And so if the California Supreme Court stays the remitter, or if a federal appellate court stays its mandate, which the California Supreme Court did here, that means that the lower court does not have the authority to proceed with executing what the California Supreme Court basically puts the effect of its ruling on hold. Yeah. That's what happens. And it is a relatively rare thing to be done. It's not unheard of, but it's relatively rare.
Yeah, so you said it's rare. Does that suggest that the California Supreme Court maybe anticipated this was likely to be taken up by the U.S. Supreme Court?
Absolutely. I think that, especially because it was a 4-3 decision in a matter where there was an explicit acknowledged split, where they basically acknowledged for all practical purposes that they were ruling differently from the Fifth Circuit and the Minnesota Supreme Court. Yes, absolutely.
Yeah.
Now, interestingly, go ahead.
I was saying it's a chicken or an egg situation. Is the fact that they stayed the remand make it more likely that cert would be granted?
That part I honestly don't know. Certainly it means the California Supreme Court thinks it'll be granted. Now I'm not aware of any studies that look to see when the lower court, be it the Court of Appeals or the state Supreme Court, stays the remand or the mandate, how much that affects the likelihood of cert being granted. I do know that I could think of at least a couple of federal examples where the Court of Appeals has granted the motion to stay the mandate and then the Supreme Court denies cert. But on the other side of that sort of leads into another thing. There is a procedure that, while it didn't happen here, the question, well, what if the California Supreme Court had denied the remitter here? Would there be any other relief that Marin Housing could have sought, to stay or to prevent this thing from going on with cert? And there actually is. They could have applied to what's called one of the circuit justices on the U.S. Supreme Court. This is where we get into what Supreme Court specialists call the shadow docket. You saw this a lot of with our former President Trump getting all these nationwide injunctions, and they go to the court, and before they even grant cert, they'd shoot down the nationwide injunction or something like that. This is a size Supreme Court practice that a lot of outside lawyers, even a lot of appellate lawyers, don't know about. What that is every justice is assigned as the circuit justice to oversee a particular circuit. What that means is if there's and the rules provide that if the lower court denies the state, refuses to say the remitter or the mandate, you can file an application to whoever the circuit justice is who's assigned to that circuit. And I'm embarrassed to admit, I don't know who the Ninth Circuit justice is right now. I think that at the time of this, it was Kagan, but don't quote me on that. And the circuit justice by himself or herself has the authority to grant the stay pending cert. And this leads to something that you used to see more of called in chambers opinion. If the justice, most of the time the justice will just deny it flat out. That I know that because that happened to me twice. That's happened to me twice in the last 3 years.
Looks like it's Elena Kagan.
It is Justice Kagan. Great. Okay, good.
It's the Ninth Circuit's guardian angel.
Yeah, exactly. And so you can have an instance. So sometimes you get justices issuing what's called an in chambers opinion. It's an opinion just of that justice. And because it's in chambers, explain why they're granting or denying the application. But you haven't seen that a lot in the last few years. Instead, what the court's been doing with most of these applications, with the ones they think are worth further review, is the justice will refer to the whole court, and the whole court itself will then issue a decision. Now, of course, that didn't happen here. It wasn't necessary. But if you get a grant of a stay pending cert, from a circuit justice or the court, that's a darn good indication that your cert petition is going to be granted. It's not guaranteed, but it's far more likely than not.
Yeah. Okay. Well, that's interesting. So let's discuss now amicus briefs more generally or more broadly. Some recent research has shown that the number of amicus briefs has grown over the past 20 years or so. And I'd like to share with our audience some stats that I found startling. They come from a May 2021 post by California appellate attorney Kirk Jenkins at the California Supreme Court Review. The post at that blog is titled "California has more amicus briefs than analytics researchers have realized." Part one of a two-part, I think it's a three-part series. So here's the first data point that I found startling, and I'll post the link to that article in the show notes. So here's the first data point. Researchers looked at two cohorts of states, and they looked at the number of amicus briefs filed in all the high court decisions in those states. So in the first cohort, totaling 19 states, amicus briefs were filed in less than 5% of the cases. So a fairly modest amount of amicus briefs. But in the second cohort of states, in which California is a member, amicus briefs were filed in over 25% of the cases. And in California, that figure was over 37%. And then here's the second data point that I found startling from that same Kurt Jenkins post. Researchers looked at the amicus heavy cohort, in which California is included, for the years 1990 through 2004. And interestingly, although the percentage of cases with at least one amicus edged up during those years, the average number of briefs per appellant didn't. And this suggests that the increase was not so much in the number of briefs being filed in the same sorts of cases as it was briefs filed in a wider cross-section of cases. So I thought I shared that with you, John, and I wondered if you can comment on that, because it seems like I think in a previous podcast, we talked about the number of amicus briefs kind of surging, and this kind of drills down a little bit and shows that it's not just the same kinds of, constitutional policy heavy cases that are just attracting more and more amicus briefs. It seems like those submitting amicus briefs are kind of spreading their efforts out into a wider range of cases.
Yes, I fully agree with you on that. And I think that reflects, well, among other things, how the appellate profession has gotten more and more specialized. And to be clear, I think this is a good thing that more amicus briefs are being filed in different types of cases across the board. I think it's good to have, as long as the issue itself within that subset of the type of case is, a major issue that's worth the court's time. It reflects a growing concern on the appellate level of lawyers in general to make sure that the appellate courts are making the right decisions based on as many good viable arguments they have before them. And I can tell you right now, like you said, I'm here in St. Louis, Missouri, and I've been filing quite a few amicus briefs on behalf of the Missouri Organization of Defense Lawyers, but that's on the defense side in the Missouri Supreme Court in the insurance defense context, which is another issue. I mean, obviously, that's the kind of thing that's definitely more of a state court oriented thing. You'll never see a U.S. Supreme Court case on interpreting an insurance policy. It may be in federal court, but that's just because of diversity jurisdiction. Yeah. But my point is, those kinds of cases can have just as major consequences for the average person as a constitutional litigation. I mean, how do you interpret an insurance policy? How do you what is coverage, what is not? I mean, we all have insurance, and that's just as important. That's just one example.
Yeah. Now, do you think if you're an appellate jurist and you've got a menu of different briefs that you can read for any particular argument, are you going to tend to reach for an amicus brief versus a party brief, depending on the kind of argument being made? Like if it's a statutory interpretation, I don't know, maybe the party's analysis will be just as good as any amicus brief. But if it's a policy argument, the parties are going to argue, for the position of whoever's paying them, right? An amicus brief might have something more authentic to say about the policy analysis.
That's a good question. My initial answer is I'm not sure I'm in terms of what the actual appellate judges and justices around this country do. I'm actually not sure what I've never seen any studies showing what their preference is for what to read first. So in terms of what they actually do, in their ivory towers and their hidden chambers. Your guess is just as good as mine. But having said that, one thing I can tell you is that at the U.S. Supreme Court level, and again, I can't guarantee this. I mean, I never had the privilege of clerking on the United States Supreme Court, but I mean, I would strongly guess that in any case, if there's a brief by the U.S. Solicitor General's office, that's the first brief that they're going to read, regardless of anything, because they've got some of the best appellate attorneys out there. They give huge deference, not deference, but they give a huge consideration to the Solicitor General. They don't always agree with the Solicitor General, but they usually have the best quality in briefing and the best written arguments, and they're the most forthright with the court about what the case is actually about. Yeah. So that much I can tell you.
Yeah. So what are you seeing in the submissions of amicus briefs or their effectiveness that maybe practitioners like Jeff and me, who I haven't sought out an amicus on any of my cases, and maybe you're seeing something that I should learn to see in some of my cases that have maybe if they have policy implications, or if they have if it's just a statutory analysis that could have broader relevance, maybe reaching out. So what sort of things are you seeing that I should train myself to look out for in maybe soliciting amicus for some of my cases?
Well, you're right. I mean, it is. Excuse me, I apologize. I think if you have an appeal and you think it's a good issue, I mean, it is worthwhile to solicit amicus briefs. I know that a lot of firms in DC at the U.S. Supreme Court level are doing that. They'll send out like an amicus memo to different organizations, different nonprofits, asking, soliciting their requests. Like here in Missouri, the Missouri Organization of Defense Lawyers, we actually on our homepage have a submission panel you could do where you can submit a request, and it's worth it. The bigger, and obviously a lot of this depends on the size of the team you have. I mean, if you have a huge team, I just filed an amicus brief on the merits in a U.S. Supreme Court case, and the party I filed it for is a very large, very well-known DC Supreme Court practice. I mean, this group had one lawyer designated as the person to coordinate the filing of all the amicus briefs, to reach out to the potential amici and make sure everyone was on the same page and whatnot. And and that goes to beforehand to soliciting potential briefs and whatnot. So yes, it is worth it. Now I will say one other thing. The one context in which I would strongly advise against filing amicus briefs, unless you have a really good reason for it, is if you're asking, if you're seeking cert in the Supreme Court of the United States, or you're asking the California Supreme Court to grant, or I apologize, if you're opposing the granting of cert in the Supreme Court of the United States, or if you're opposing the California Supreme Court accepting discretionary review, it's typically not considered good to file an amicus brief in support of the argument that the court shouldn't grant review. And the reason for that is you don't want to draw more attention to the case than it should. Like if you're opposing review, you want to minimize, say, look, they made the right decision below, it's no big deal. And filing amicus briefs in that context, unless you have a really good reason for it, is just going to bring more attention to the case for the court. And the court could very well be like, well, wow, look, all these parties opposing the granting of, saying we shouldn't grant this. Well, the facts, the way people are concerned, there's clearly something there. We better grant it.
Yeah. A lot of subtle analysis going on here.
Yeah.
All right, Jeff, I think it's that time in the show where we get to the lightning round.
Okay. Hey, John, have you listened to this show before?
I'm embarrassed to say no, I haven't. What is the lightning round? I'm super excited to hear.
Fantastic. Then you'll be surprised by each of these important questions that vex appellate nerds around the globe. We're looking for short responses, one sentence perhaps, of these very vital, important questions. Here we go. Font preference, Century School Book, Garamond, or something else?
Century School Book, without question.
That's the right answer.
Yeah.
Good. I'm on the right show. Good.
Yeah, and we appreciate your emphasis as well. Lack of
Yes.
equivocation.
Yes,
2 spaces or 1 after a period.
1, without question, once again.
Oh, you're making
Yeah.
friends with Jeff today.
Pled or pleaded?
Yes. Allow my appellate Twitter. I'm sorry, say it one more time. What was it?
Pled.
What was the question? I'm sorry. Or pleaded. Pled.
All right. Very good. You're 3 for 3.
Yeah, no, I'm going to have to count you down on pled. You're just irregularizing verbs willy-nilly.
So what? But that means nothing. No, just
I thought you were a strict constructionist, John.
well, no, I am an originalist. The originalist is not the same thing as a strict constructionist, but that's a debate for another time.
And another show.
Fair enough.
All right. Fantastic. 3 for 3. You're welcome to come back anytime. Any parting thoughts you want to impart upon our California listeners to our audience?
Just that appellate. If for those who are, well, what's the difference between an appellate practitioner and a trial practitioner? The trial practitioner can be likened to the high school quarterback on a Friday night who gets all the glory. He gets the job done and everything. The appellate practitioner is the nerd that does the high school quarterback's homework for him to make sure that everything's in line. And unlike high school nerds, the appellate nerds love doing that and staying out of the limelight. That's the difference.
Well, it's very inglorious and self-deprecating to us, but I think it's fairly accurate.
Yep.
All right, John, we appreciate you coming on the show and taking some time with us.
My pleasure. Thanks, Tim. Thanks, Jeff.
All right, Jeff. Well, let's get to some recent appellate news and tidbits out of the California Court of Appeal. And John agreed to stick around with us and listen in. And if he has any pot shots, he'll chime in with them.
Okay, great. So one case that caught my eye, it's from March of this year, but it caught my eye because I was recently lecturing to some CPAs about best tips for testifying as a forensic expert. And a case caught my eye involving Jillian Michaels, one of the trainers from The Biggest Loser, that weight loss show.
Oh yeah, I used to hear her on the radio all the time.
Yeah. So she had a case. It's Michaels versus Greenberg Trarig, 2021, 62 CALaw 5th 512. And I'll put it in the show notes. The thing that caught my eye about this case is, first of all, it's a legal malpractice case. Sargon was used to try to exclude expert testimony.
Yeah, Sargon's that big recent California Supreme Court case that says that speculative expert opinions will be excluded.
Yeah, and more specifically, before a jury hears testimony, the judge is supposed to act as gatekeeper and keep away from the jury any speculative opinions. The interesting thing about this Michaels case is it's an MSJ case, and on summary judgment, Jillian Michaels offered up an expert opinion regarding millions of dollars in damages that she suffered as a result of malpractice. And at the trial level at MSJ, the court applied Sargon and excluded it. And that result was reversed on appeal in the second district case that came out in March. What I found interesting is that the second district found that at the MSJ stage, unlike right before trial, right before a jury is going to hear evidence, at the MSJ stage, opposing declarations are to be construed liberally, and experts don't necessarily need to lay the foundation for their opinions and explain their methodologies to the same degree and with the same specificity as is required at the time of trial. So it gives those opposing an MSJ, most often plaintiffs, a little more wiggle room and a little more vagueness in terms of offering up expert testimony. It was an interesting decision, and I highly encourage trial lawyers to read it.
That is interesting. Is that a second district case, Jeff?
Second district, Division 8.
Because it reminds me of a case I was reading, I believe, out of the fourth district that came to the opposite conclusion. I don't believe it was on a motion for summary judgment, and it was a personal injury case against Caltrans for a design defect of a highway interchange off ramp, and the plaintiff's expert submitted declaration stating that there was a design defect, and the government, Caltrans, asserted the defense of design immunity, and the court granted the Caltrans summary judgment. And even though plaintiff's expert declaration seemed to create a triable issue of fact that was disregarded. I think this case seems like it cuts the other way on that.
Yeah, I recall us discussing that case in one of our shows, and
Yeah, I'll see if I can
I
dig
thought-
that up and put it in the show notes.
okay, great.
And also when you mentioned this Jillian Michaels case to me, it reminded me a few episodes back, you had told me that you had never seen a court of appeal reverse because of an incorrect evidentiary ruling made by the trial court. So after you mentioned that, I set out to find a case so I could rub your nose in it and prove you wrong. And it took me a while, but our listeners might want to take a look at a second district case from June 2021, Nicholson versus Southern California Edison Company. It's an unpublished opinion, but the case involved an injured electrician who sued Edison for negligence, but the trial court granted summary judgment for Edison by excluding the plaintiff's testimony. And the Court of Appeal held that this was an abuse of discretion. The evidence was based on personal knowledge, so the ruling was incorrect as a matter of evidence, and the evidence was relevant to a material fact, so it was prejudicial.
All right. Well, consider my nose rubbed. But to clarify, what I was saying is I never had one of my appeals reversed on one of those grounds. But point taken.
All right, but I'll be watching your cases then, Jeff.
And then I also want to point out that California every year puts out statistics regarding the number of cases that are filed in the Superior Court and the Court of Appeal, and how they're disposed of, and how long it takes for each court and each district to resolve cases. I always find reading this report interesting. A new report was just issued, and we'll link to it in our show notes. But the thing that I found most interesting is always the number one question I get from trial lawyers is, how long is this appeal going to take? And this report shows that 90% of all appeals, from the moment the notice of appeal is filed to opinion, the shortest disposition for 90% of appeals is in the Second District Division 6 at 687 days. That's from the filing of the notice of appeal to opinion. And the longest is the Second District Division 1 at 798 days. I always find that interesting to see the trends in terms of how long it's taking for opinions to come out on cases.
Is that the longest? I thought the longest had been coming out of the 6th district, if I wasn't mistaken. I wonder if they dropped out of the running. Maybe because they transferred a lot of cases out.
Maybe we could do a deep dive. Now, keep in mind, this is for 90% of the cases. And I wonder if that 10% contains some outlier cases. The other interesting fact is this tracks, the statistics report tracks criminal, civil, and total rates of affirmance. And in this latest report, 78% of civil matters result in being affirmed by the courts of appeal. And that's slightly lower. The prior year was 79%. So I don't know if there's a trend there, but it's interesting.
Yeah, okay. All right.
Well, that wraps up this episode.
If you have suggestions for future episodes, please email us at calpodcast@gmail.com. That's calpodcast@gmail.com. In our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
See you next time.